Greetings, everyone, and welcome to Adverse Possession, Time and Title from American Jurisprudence. Tonight we're going to be going over adverse possession and the titles and how they're acquired in that way. We also have with us a Black's Law Dictionary, which will help us with any words that we need to find along the way, so we leave no word behind. Let's get this guy centered here. And we're ready to go. And we're going to be looking through AmJur, second edition, adverse possession. That being said, let's zoom in a little bit here and let's get started. Is anyone in here in the room? Hit the like, leave a 1 in the chat so I know that people are here so we can get started. Any questions along the way, I'll be monitoring the chat so that we can get questions answered while we have all the resources available here, and that will always be included for the stream. So let's move along here. Again, we're going to be going over second edition American Jurisprudence, February 22nd, 2022 update. We'll start with a summary. Scope. This article discusses the adverse possession of property with discussion of the nature, elements, and requisites of adverse possession. Persons who may acquire title by, as well as persons against whom title may be acquired by adverse possession. Particular types of property and estates affected by principles of adverse possession. The operation and effect of such principles, and matters of practice and procedure related to the subject. So it looks like we're going to get the whole lowdown on adverse possession. So we're going to look at the nature of it, the elements, and the requisites. The persons who may acquire title by adverse possession, as well as persons against whom title may be acquired by. So this looks pretty interesting. Let's look at this. Particular types of property and estates affected by principles of adverse possession. So we'll look at the universe of properties that could be affected by this principle, and the operation and effect of such principles. And then finally, the matters and practice and procedure related to the subject. So let's continue. And treat elsewhere will have things like generally abandoned property, abandoned lots and unclaimed property, adjoining landowners, advancements of land by parole gift, which is a verbal declaration, color of title act. So there's a lot of other ones for Secretary of Interior patent upon land. So a lot of things here that are in other episodes or other volumes of American Jurisprudence. But let's get right into what we're doing here tonight, and that is Section 1, Nature of Adverse Possession. So also within the American Jurisprudence, we have an acquisition of title to property by adverse possession, and that's in proof of facts. So that's another good one to look at, too, in proof of facts. That'll be in the 39. All right, let's continue. So, adverse possession, this is the nature now, is a method whereby a person who is not the owner of a property obtains a valid title to that property by the passage of time. What a concept. The concept of adverse possession allows a person to claim title to property presently titled in another, and permits one to achieve ownership of another's property by operation of law. Now, that seems pretty strange in and of itself, doesn't it? Someone else has claim presently. How is someone going to get it through the passage of time? So let's look at this principle. Adverse possession is thus recognized as a mode or method of acquiring title to property, but it is not a favored one. So, cumulative supplement here, we have cases. An adverse possession claim is really one for recognition of title and enforcement of the rights that accompany title. So that's really what we're trying to understand here, and that's in a 2014 case in Vermont. But the claim is really one for recognition of title and enforcement of the rights that accompany title. Beautiful. So then we have the cases here, and let's see what years here. So they're pretty recent. And as the operation and effect of adverse possession, we'd have to get sections 231. That's way down in this volume. Let's proceed. Section 2, definition of adverse possession. Adverse possession has been defined as an actual and visible appropriation of property, commenced and continued under a claim of right, inconsistent with and hostile to the claim of another. It has been defined also as the open and notorious possession and occupation of real property under an evident claim or color of right, or in other words, a possession in opposition to the true title and record owner, a possession commenced in wrong and maintained in right. What a concept here. Hey, Deanna. I haven't seen you all. There it is. Okay, so we have a possession commenced in wrong and maintained in right. Observation: in some jurisdictions, the term for adverse possession is virgin title. So we got some interesting concepts. Let's see what number 1 was. One was this: the under a claim of right inconsistent with and hostile to the claim of another. That's footnote 1. 1960, that looks like Arizona, and 1945, Texas. Writ refused. And we have another one, Utah, 1982, as the elements of adverse possession, generally, section 9. We'll get to that soon. So number 3 was Blankenship versus Peyton in Mississippi, 1992. So that's in that jurisdiction. I guess they call that a virgin title. And that was what jurisdiction? Mississippi. Okay. Let's move along. Governing law. Section 3. Adverse possession is an amalgam of statutory and common law, and is governed by both common and statutory law. In some states, adverse possession may be established either under the common law or pursuant to statutory provisions. In other states, there is only one adverse possession claim, which is the common law claim as amended by the legislature. So, an interesting thing here. So these claims, we're making a claim to a title. The common law claim to the title is usually the equitable claim. Let's see here. Observation. Statutes providing for the length of time during which an adverse possession must be maintained to ripen into title are not objectionable on the theory that they deprive the owner of the property without due process of law. So, statutes providing for the length of time must be maintained to ripen into title, which in adverse are not objectionable on the theory. Oh, okay. Wow, that's pretty interesting there. That's case or footnote 5. Let's see what that is real quick. 1903. 1904. So those are some pretty interesting cases there. well-established law, common law there, I'd say. All right, and cases here in the cumulative supplement. Amendments to adverse possession statutes that added good faith requirement applied to adverse possessor's claim to record owner's parking lot, which was adjacent to adverse possessor's property, where amendments expressly applied to claims that had not yet vested before enactment. An adverse possessor's claim had not yet vested before amendments were enacted. In that her period of possession of parking lot began about 1 year before enactment of amendments. That was Alaska in 2017. Pretty interesting there. So this is a parking lot issue here. It's adjacent to the adverse possessor's property, where amendments expressly applied to claims that had not yet vested before enactment. Any adverse, so the ripening hadn't occurred, right? An adverse possessor claim had not yet vested before amendments were enacted. Okay. Yeah, about 1 year before enactment of amendments. Wow. Well, that seems like something that needs to be read into. And that's 2017. Again, when these newer cases are out there, they're usually go against usually well-established common law. So I get always suspicious of the judges that are making these rulings. I'm not sure how the judges are there in Alaska. Under statute governing adverse possession, the version of the law in effect at the time the purported adverse possession allegedly ripened into title is the law applicable to the claim, even if the action was commenced after the effective date of the new legislation. So, again, 2020, geez. New stuff here. Holding companies, huh? Real estate, postal realty, yeah, of course. Okay. The rationale behind adverse possession lies in the sound public policy to encourage those who diligently develop and improve the land, as against those who are content to hold the bare legal title inactively for many years. Now, that's a nice one there. And that was recently, though, in 2019. The rationale behind adverse possession lies in the sound public policy to encourage those who diligently develop and improve the land, as against those who are content to hold the bare legal title inactively for many years. So you get a definite feel for the intent now of adverse possession. I think it's encapsulated very well here as the main difference between those who are content to hold a bare legal title inactively, as opposed to someone who will diligently develop and improve the land. Interesting stuff here. Let's move along. Governing law. Conflict of laws. Section 4. So, in an action based on adverse possession, the law, as it exists at the time the adverse possession is perfected, and title passes control rather than the law as it exists at the beginning of the adverse occupation. So, law as it exists at the time the adverse possession is perfected and title passes control rather than the law as it exists at the beginning of the adverse occupation. So possession, occupation. So the law in action based on the adverse possession will be at the time it's perfected. Another thing to be considered about, and that's why I titled this time entitled, because the main consideration here, aside from the intent of improving and developing land, is the time. The time factor actually plays into the claim. So it's a very interesting concept. It's definitely a common law concept, but you can see there's statutory elements woven in. That's what we're reading about right now, is when there's conflicts, supplementary, complementary, and ones that will supplant others. You have to be aware of, depending on your jurisdiction and when you're trying to acquire a title. But before I go any further, I just want to remind everybody that this is strictly for entertainment purposes and educational purposes, and is no way meant or intended to be any kind of lawful legal advice in any way, shape, or form, nor should it be used for any type of legal action or actions on your part for anything that's related to any kind of matters other than just strictly enjoying yourself here on YouTube. Don't try this at home. That being said, let's continue. Even if the law permits the acquisition of the title. All right, we got Disciple of the Messiah in the house. Excellent. All right, so adverse possession. Even if the law, the disclaimer, we got to have one. Even if the law permits the acquisition of title by adverse possession of certain property from the inception of the possession, title to the property cannot be so acquired if a statute is enacted before the expiration of the required period of adverse possession, prohibiting the adverse acquisition of the title in that kind of property. I hope that makes sense. But what it's saying, all right, let's get this timeline. Remember, the big thing about adverse possession is time, and to focus on time factors. So let's look at this. Even if the law permits the acquisition of the title by adverse possession of certain property from the inception of the possession. And say occupation says possession, the inception of the possession, right? Title to the property, acquisition of title, right? By adverse possession. The law permits acquisition of title. Title to the property cannot be so acquired if a statute is enacted before the expiration of the required period. Okay, so it seems like this is like a grandfathering in clause here. Further, where title has vested by adverse possession, it may not be disturbed retroactively by newly enacted or amended legislation. There you go. And thus, statutory changes to the law governing adverse possession do not apply to property owners whose rights to the disputed land had vested prior to that time. So, timing is everything with these adverse possessions. Inception of the possession. So that's a good time to take a digression here, a sidestep into blacks, and let's find out what the legal term exactly is of inception, if there is any kind of one distinct from the normal dictionary definition. Because what I've found is quite frequently, it looks like it may be. Oh my gosh, okay. Let's see, H-I... Okay, here we go. I guess that's close. No. We'll try it from here. I have to go a little bit by hand here. Shouldn't be too hard to find here. Inception. Come on. They want to skip all the way to the J's. But I know it's here. Inception here. We're getting close. Oh. Oh. Okay. It doesn't look like they have a good definition here. So just standard definition of inception. The establishment or starting point of an activity. So we'll just go with that. But I like to be certain about this stuff because, as we know, when it comes to the law, they always like to use specific definitions that are specific for the subject matter. And now we're assured. So the initiation of the action of possession. So let's think about that. The inception of the possession. that was on this one here, right? The law permits the acquisition of title by adverse possession of certain property from the inception, the initial activity, right, of the possession. Title to the property cannot be so acquired if a statute is enacted before the expiration of the required period, so the ripening period. I got you. But when the title has been vested by adverse possession, it may not be disturbed retroactively by newly enacted or amended legislation, and thus statutory changes to the law governing adverse possession do not apply to property owners whose rights to the disputed land had vested prior to that time. So there it goes. After the time's up, it's whoever is in possession of that title. Audit them. Welcome. So, the law of the state in which the real estate is located determines whether title has been acquired by adverse possession. And the acquisition of title to personality. All right, now we have a new word to look up. Personality. Give us a second here. Hopefully that's not littered throughout blacks, but looks like it is. Jeez. Okay. One of those words. Here we go. 88. Okay. Personality. 16th century. It's personal property as distinguished from real property. Jeez. There's all kinds of quasi-personality, things that are considered movable by the law, though fixed to real property, either actually as a fixture or fictitiously as with a lease for years. Wow, a quasi-personality. Interesting word. Hey, we got Los Angeles Spike with its number 7 Esquire pencil handy. Great, let's continue here. All right. So, the law of the state in which real estate is located determines whether title has been acquired by adverse possession, and the acquisition of title to personality. So that means it could have been from the, I guess that the lease or something like that, right? By adverse possession? How does that quite work? Something movable. Acquisition of title to personality by adverse possession. Oh, maybe it's something on the property. It's governed by the law of the state. Okay, so it's there we go. So personality in this context seems to refer to personal property. Seems like the quasi-personality fits it pretty good here, because you see on here they have though fixed to real property, either actually as a fixture or fictitiously as with a lease for years, but there could be fixtures on the property. Interesting. But the only way we know for sure how they're really meaning it here is, of course, to look at footnote 6. And that would be, in this case, restatement second, conflict of laws. So we could look under conflict of laws and see the restatement. But that won't be tonight. Okay, so there, now we understand this. So the personality by adverse possession is governed by the law of the state in which the property was situated at the time the transfer took place. And the property we're talking about is actually, I think, the personality, not the real property that's located on, which is not movable. So, tight words here, very important to know what they mean because they're very rigid in their meaning. They're not open to much interpretation outside of the statute, Black's Law, and then, of course, your standard dictionaries. All right, let's continue. Cumulative supplement. So we have cases here under federal common law, choice of law. The law of Spain governed Art Foundation's claim that it acquired ownership of painting by adverse possession. Spain, where transfer was claimed to have taken place and where painting had been located for more than 20 years, had the dominant interest in determining the circumstances under which ownership of the painting could be acquired by adverse possession or prescription. Oh, there you go. Someone leaves something with you for too long, and on your property it becomes adverse possession. I believe that's what that is. Interesting there, huh? That's in, 2015, California. All right, do we finish this? Yes, we finished this section. We're all good. Let's move on to the next section here, and we're on to construction of doctrine of adverse possession. The doctrine of adverse possession is to be taken strictly or strictly construed. Since adverse possession may deprive true and legal owners of their property, strict compliance with statutory requirements by those seeking ownership through adverse possession is required. Moreover, a claim of adverse possession must be construed strictly in favor of the owner of the title. Strictly or construed strictly, since adverse possession may deprive true and legal owners of their property. Strict compliance with statutory requirements of those seeking ownership through adverse possession is required. Moreover, a claim of adverse possession must be construed strictly in favor of the owner of the title. So we have a lot of cases here, 1962, 2004, 97, 97, 2007 in Florida's 1st District. We have 2007 in Ohio. Interesting. On the statutes of limitations as basis, Section 6. Adverse possession has been held to be based on or developed from the statutes of limitation on actions for the recovery of property. Indeed, an adverse possession statute serves as a statute of limitations, prohibiting any claim to the property unless possession adverse to the owner has continued for a period of time. Adverse possession statutes, like other statutes of limitation, rest on a public policy that regards litigation with disfavor and aims at the repose of conditions that the parties have suffered to remain unquestioned long enough to indicate their acquiescence. Interesting concept right here. Like other statutes of limitation, rests on a public policy that regards litigation with disfavor and aims at the repose of conditions that the parties have suffered to remain unquestioned long enough to indicate their acquiescence. So the purpose of adverse possession statutes is to quiet title to property. And the intention of such statutes is not to punish one who neglects to assert rights, but to protect those who have maintained the possession of property for the time specified by statute under claim of right or color of title. Heavy stuff. Hey, we got the wizard in the house. Salvage laws of abandonment under admiralty law. We're not going to get an admiralty law tonight, though, but I do have a whole nother section for that. But we'll get lost at sea with that tonight. This is enough on our plate. Greetings, El Perro. Great to see you here. Greetings. All right, let's continue here. Observation. An adverse possession statute creates a period of limitations on an action to quiet title that runs only against the record owner of the land. The adverse possessor is under no duty to quiet title by judicial action, nor to vigorously assert his or her right at every opportunity. Wow. Now that's a concept there, I'd say. it creates a period of limitations on an action to quiet title that runs only against the record owner of the land. So the possessor is under no duty to quiet title. Interesting stuff here. This really puts the highest priority on the possessor, the adverse possessor, because remember, the adverse possessor is the one that maintains, improves, and develops the land, and the other one is merely just holding legal title to the land. That's not doing anything to it. It's being very inactively held. So which party has a legitimate claim? And the intent, again, is public policy, regards litigation with disfavor. And, in the repose of conditions that the parties have suffered to remain unquestioned long enough to indicate their acquiescence. So, again, it's to quiet title of property is the purpose of the adverse possession. And the intention of the statutes, think of it like this, it's not to punish one who neglects to assert their right. So it's not saying you have to do something, but it's to protect those who have maintained possession of the property for the time. Here's our theme again of time, specified by the statute under claim of the color of title. That means that statute, when you do it, they're going to protect your claim. Then the state has, they will do that because that's what maintains the order, is the record of title of private property. It's pretty much the job of the state to do. It's their duty. So, that being said, this is a really nice thing to look at here. This is footnote 6, and that's Carnival versus Dupuy, and that's in Rhode Island, 2001. And then we have a whole bunch more here. So adverse possession of abandoned land is maintenance versus actual ownership by legal or equity title. I think strictly legal title, because you're actually establishing a bit of an equity title by living on the land. I think that's what it's kind of leading at, but we're going to find out as we go along. But good observation here. It is the essentially the maintenance of the land versus just holding legal title inactively, essentially. So the action, intent, these all play into the law. Now, whether they're in the statutes or not, but the statutes are going to be the boring, dry stuff that's probably going to say in this state, public policy is this many years, and this state it's going to be this many years, and it probably depends upon density, availability of land, etc. We know how politics goes. So that's where that goes. But remember, the American jurisprudence is, its main body is of common law. So we're really trying to focus more on the common law aspects of the legal system. And exactly, the equity will always provide remedy in these cases. And that's one of the great things about American jurisprudence, our system of justice here, is that we have the equity woven into our judicial system in somewhat the same way our other courts are maintained, our civil courts. And in other countries like Britain, it was always, equity was kind of left to the side as something for the king to decide, courts of chancery and such. So it wasn't really a true equity in the sense that you had peers deciding or any kind of proof of facts. It always rested upon the king to decide. So what we're looking at here are some pretty deep concepts that run to the heart of what makes America really great. So that being said, private, well, yeah, now we're getting lost in the weeds there with the private equity. But yeah, and a man come in on the law side and push them into private equity. Yes, and the thing is that when there's a function of keeping the legal side of the title registered and recorded, it ends up being abused in a way that the equity is marginalized, so that you'll find that the courts don't recognize these equitable elements so easily unless you really point it out. And that's what we're doing right here, because you'll find that a lot of the esquires just coming fresh out of law school probably don't spend as much time on American jurisprudence as we're doing right now. So my salute to all of you that are here in the room right now. So let's proceed. So presumption of grant or conveyance. Remember, the conveyance is the voluntary transfer of the property. So presumption of grant or conveyance. So grant, gift. So let's see what we got going here. Title by adverse possession has been held to rest on a presumed grant or conveyance, or on the presumption of a lost grant. In other words, if it is shown that one has held an uninterrupted possession of property for a long period of time while exercising proprietary rights, the law raises a presumption of an ancient or lost grant of title. Wow. You got that right, El Perro. I don't know either. I don't think they even know in law school what they're missing. But they do teach them a lot about how to maneuver the legal system. I don't think they teach them very much about law, and especially our style of law, American jurisprudence, which is focused more on the intent and the adaptability of laws through the common law approach, where the laws are adapted to the needs of life, instead of trying to make our lives adapt to their statutes and codes. All right, let's continue here. This presumption is one of policy as well as of convenience, and is necessary for the peace and security of society. It is founded on the consideration that the facts are such as could not, according to the ordinary course of human affairs, occur unless there was a transmutation of title to, or an admission of an existing title in, the party in possession. Wow. The presumption of a lost grant to property recognizes that lapse of time may cure the failure to secure the proper muniments of title, even though the lost grant may not have been, in fact, executed. Lost grant. Wow. There's some concepts here. Monuments. I know we need to look this one up here. I know I've known this word before. I thought it had something to do with money, but let's see. Oh gosh. How do we spell this again? Monuments. Monument of title. That looks like a good one. Oh no, this ain't the right one. Jeez. 330. No. All right. Monument. Muniment. Okay. Muniment. There we go. Muniment, a document such as a deed or charter, evidencing the rights or privileges of a person, family, or corporation. Muniment. So it's a document evidencing the rights or privileges of a person, family, or corporation. Deed or charter. Deed. Muniment of title. This looks closer here. 1806. Documentary evidence of title, such as a deed, right? The deed was that transfer, record of transfer, or a judgment regarding the ownership of property, also termed common assurance. See chain of title. Nice. Okay, so muniment and muniment of title. We got it. And while we're at it, I think we'd be, as El Perro's pointing out here, I know what grant means, but it seems like they're really dwelling on this word grant, and it seems like we need to find a thicker definition of it from Black's. So let me see if that's in here. I'm sure it is. Oh yeah, gosh, a million times. See if we can find the actual, just the word grant. Wow. Almost there. A lot of words with grant in it, I'll tell you that. Okay, now we're getting there. On. Here we go. Okay, come on, really? Okay, there we go. Grant. On the screen, yes. 13th century, an agreement that creates a right or interest in favor of a person or that effects a transfer of a right or interest from one person to another. Grant, an agreement that creates a right or interest in favor of a person or that affects a transfer of a right or interest from one person to another. Examples include leases, easements, charges, patents, franchises, powers, and licenses. The formal transfer of real property is a grant. Land grants, things like that. Okay, so formal transfer of real property, the document by which a transfer is effected, especially a deed, so deed, grant, the property or property right so transferred. So we got all kinds here. We got community grant, grant to real property made by a government, and escheat grant, a government grant of escheated land. Well, they do a lot of cheating of land, that's for sure. Imperfect grant, a grant that requires a grantor to do something before the title passes. Inclusive grant, office grant, perfect grant. Let's see, private grant, another grant. Well, here's a verb. So that was a noun, so the verb to grant. To give or confer something with or without compensation. The grandparents granted the car to their daughter on her 16th birthday. I'm sure it was a fancy car because they didn't gift the car, they granted it. To formally transfer real property by deed or other writing. The Lewisons granted the townhouse to the Bufords. To permit or agree to, the press secretary granted the reporter access. To approve, warrant, or order a request. Motion, grant a request, grant a motion. The court granted the continuance. International law, see subsidy. So there we go. So a grant in the verb is just generally to confer. It could be a formal transfer by deed or other writing. And that's probably what we're talking about here in this case in the verb is definition number 2. To formally transfer real property by deed or other writing. Okay, let's get back. So, as we were seeing here, muniments of title, even though the lost grant, lost deed, whatever it was, may not have been, in fact, executed. So we got here, I'm beginning to write up a writ for an injunction concerning my Social Security mask incident. Since it appears they breached the trust by not allowing me entrance in personam. Yeah, in personam, yes. Injunctions, we could go over that next. Estoppels, injunctions, those are, anyhow, that gets into our equitable remedies. So let's continue here. At the end of the appropriate statutory limitations period, the presumption that there was a grant crystallizes into a rule of law and becomes irrefutable. Thus, if property is maintained in adverse possession for the statutory term, the law presumes a conveyance. Wow! Now that's cool. It crystallizes the grant. And this includes a presumption of the occurrence of all matters essential to give the conveyance effect. Number 9. That's 1929, so well-established law on that one. Beautiful. All these are pretty well done. So this section here is presumption of grant or conveyance. So that's it. It's presumed loss, but it crystallizes as into a rule of law and becomes irrefutable. Is that irrebuttable? So that's a great section there. I'd say that everyone should, if you took notes on that, section 7 definitely has some gems in it. And we're on to section 8, which is distinguishing adverse possession and prescription. So the term adverse possession should be distinguished from prescription. The terms differ principally in the nature or the right or the kinds of land interests acquired, with adverse possession resulting in actual and complete legal title to the property, and prescription resulting in the acquisition of rights in the land of another, such as an easement. In adverse possession, the claimant occupies or possesses the land of the fee owner, while in prescription, the claimant makes some easement-like use of it. In some jurisdictions, however, the acquisition of title to property by adverse possession is called prescription. Oh, geez. Just to confuse you. To the extent that an analogy exists between adverse possession and prescription, the statutory rules for one should be applied to both. So if there's an analogy between the two, then the rules apply to one, apply to both. If not, then there's a distinction. However, if the question involves the kind of physical conduct requisite to gaining an easement by prescription, the conduct ordinarily required for acquiring the title to real property by adverse possession affords no analogy, because one does not possess or occupy an easement or any other incorporeal right. That is heavy there. So think about it. You can't, camp on the easement and then claim it from adverse possession. But by prescription, it can be. So that's rights to use of it. So prescription applies to easements more, I guess, in a general sense, and possession, adverse possession applies to property properly. Let's proceed. Wow, this is pretty good stuff. While prescription is measured by use rather than possession, the adverse use necessary to acquire a prescriptive right generally must commence in the same way and be of the same general character as the adverse possession required to give title to real estate. In either prescription or adverse possession, the right is acquired only by actual, continuous, uninterrupted use. You guys get this? Actual, continuous, uninterrupted use or possession by the claimant of the property of another for a prescribed term. In both situations, the use or possession must be inconsistent with the owner's use and enjoyment of the property and must not be a permissive use. So someone you're leasing it to because they stay in there for a statutory amount of time doesn't mean they can claim adverse possession. It has to be inconsistent with the owner's use and not a permissive use. So, you see, now we're getting to the meat of the stuff here, and that's the beauty of American jurisprudence. We start with the foundational concepts, the intentions, and the history of it, and we see how it's developed to where it is today. As you can see, as we get further into it, there's more conflicting laws and statutes and statutes and codes and other municipal encroachments that start to corrupt the common law that we saw originated in the discussion here. And now, once you see the modern courts and judges, as they start to add in more and more, and the legislatures that like to get, to divvy up some more pieces of the pie for themselves, we see more encumbrances to things that have been pretty much well established by public need and public policies. So let's continue here. In some states, a period of time within which the right to property by adverse possession and the right to an easement by prescription ripen is the same, but in other states, the period of time is different. So there you go. And this goes to acquisition of an easement in the land of another through prescription, and that's under easements. We could go over this too at another time. Permissive possession, 1958, wow, in Florida. And as to the duration of adverse possession generally, see Section 12. We'll be there very shortly. All right, let's see how everything's going here. Looks like the stream is still pumping, and we're good to go. Let's keep moving. We're on to Section 9, generally. In order for a party to establish title or ownership to property by adverse possession, the possession or use of such property must be hostile, actual, exclusive, continuous, and open and notorious throughout a prescribed period of time. It is also generally necessary that the possession of the property be under a claim of right or title or color of title. In some jurisdictions, the payment of taxes is also necessary. Some jurisdictions also require that the possession or use of the property be visible, or that the possession be accompanied with an intent to hold against the true owner. When these elements coincide, title by adverse possession is acquired. And we got, all right, Michelle Moretti in the house. Welcome. And Brian O'Shea, the world famous Brian O'Shea, the future of comedy. Welcome. He could be the very next adverse possessor. We all could be. Come on, go away. So you get these things off. There we go. Okay, let's proceed. So we're seeing here how this is pretty clear here is that you can't be under buddy-buddy with the person that has a claim or the color of title to the property. Again, in some jurisdictions, the payment of taxes is also necessary. Now, so number 4, where's that? Section 136. I'm not too sure where that's going to be. That's a little troubling there. But, that's some jurisdictions. Some jurisdictions also require that the possession or use of the property be visible, or that the possession be accompanied with an intent to hold against the true owner. Okay, payment of taxes. So if it's a business, perhaps, you would have to be paying taxes. So this may not apply only to, you could actually start a business with adverse possession. Because remember, we're talking about persons and corporations owning this stuff too. Yeah, any taxes. So it would be business taxes. I don't think property taxes are necessarily a requirement. Some states don't even have it. So the jurisdiction matters here. But again, the payment of taxes, it doesn't say property taxes, private property tax. It doesn't say any of that. So I would assume that it would be lawful taxes, which would be if you're under contract with a particular jurisdiction or municipality to engage in commerce within their jurisdiction, then yeah, you would be paying taxes to them based on your tax returns. And that would be a way of establishing your adverse possession, that you have been maintaining the land. Argue necessary what? Okay, so if you're talking about necessary taxes, you'd argue necessary. I see. It is necessary in some situations because if it's a business tax, right, you would be under contract. If you're, let's say you're engaged in legitimate commerce within a municipality and you've registered with that municipality to conduct business there. They're providing services or whatever you needed there, and you'd be paying taxes with them. In that case, that jurisdiction, that would be an element needed to prove that, yes, you've been functioning there on that land. You've been running a business, and you were able to acquire that land by running your business on it for that statutory period of time. And now you're claiming your adverse possession. And part of your claim is that you've been maintaining the land because you've been running a business, paying your taxes on it. And some jurisdictions are going to probably say if you're going to be running a business there, you also need to be paying your taxes for running the business there, which makes sense because taxes are for commerce. It doesn't say property tax. It says taxes. So, again, we could get into this section too. Matter of fact, if we want, we could take a quick detour to it. Let's see, we're on page 21, and it says it was on section, which was a footnote 4. Footnote 4, and that's section 136. Let's see. A little bit further here, we could find it real quick and see what it says here about that, because I'm kind of curious myself. So I was kind of reading that first saying, yeah, business taxes, because it said before that corporations could be making these claims for 136, it said, right? Okay, 34, 35, and 36 generally. Okay, here we go. Under some state statutes, payment of taxes by an adverse claimant of property is a requisite to establishing title by adverse possession. In those jurisdictions, statutory requirements must be met, or title by adverse possession cannot be established. The payment of taxes need not be shown, however, if no taxes had been levied or assessed against the property. See? So the payment of taxes based on an illegal or void assessment does not constitute compliance by an adverse claimant with a statute requiring the payment of all taxes legally assessed as a condition of adverse possession. That's an interesting one there too. So it has been held that neither the purchase of land at a tax sale nor the redemption of land from a tax sale ordinarily constitutes a payment of taxes within the purview of a statute requiring the payment of taxes by an adverse claimant. Wow. It has also been held, however, that an adverse claimant's payment of back real estate taxes by redemption qualifies as payment for the purposes of adverse possession. Oh, so they could hold you, you got to pay those back taxes. Hey, Archangel for Truth. Need it out here. Tremendous. Come on, light up there. There we go. So there's another little curveball. And the first footnote. So let's look at this. For statutory adverse possession, which has a shorter time requirement. Wait a second. So okay, payment of taxes, yeah. Okay, so it is footnote 1. So let's see what we got here. 1991, 81, 61, Florida 2007. Adverse possession without color of title. Oh. So these are all look at all these cases. 2013, 1989, 2000. So there's quite a few cases here. So all these cases are worthwhile looking into considering taxes. No is usually the right answer on this one. Yeah, property rights often refer. Let's catch up with some of the chat here. The property rights, often referred to as a bundle of rights, is comprised of several different rights called a bundle. And yeah, that's true there. No is always defined. Yep. Oh, cool. Yeah. No, I get it. So there we go. We got pretty much a good insight there. So the tax thing is going to be based on these cases here if we want to find the true answer, because there's a lot in there, and we have to unpack it by reading the text of these cases here to see exactly where it applies in your jurisdictions. As you can see, they're in all different states: California, Arizona, Arkansas, Florida. You got pretty much the whole gamut here. Alabama. So let's continue. But that was a good little digression there. So thanks. That was You Have Rights, Cops Have Duties that recommended that one, right? Got a little troubled by that property taxes there, huh? All right, let's get back to where we were. Actually, I can just type it in here as 21. Okay, so back to General Lee. Okay. We get through this part here. Wait, did we get all this? So we are. Okay, yeah, we already read this part. I believe, yes, section 136. So we get into necessity. Wait, do we finish it, though? Getting a little lost here. The worst part about American jurisprudence is some of these things get repeated just because they're referred to twice in the footnotes you'll see, and it's a good way of reinforcing some important parts, but it can be confusing when you're reading it in the digital form like this because you think you're on a different page. So let's read this here. To constitute an effective adverse possession, all the elements for such a claim must be satisfied, and if any elements are not satisfied with the possession will not confer title. Purchasers of a southern portion of tract of real property acquired title of the northern portion by adverse possession under the 10-year adverse possession statute. Purchasers entered into an earnest money contract and a purchase and sales agreement that included northern portion, although eventually deed did not. Purchaser paid tax on the entire property, and purchasers visibly appropriated the northern portion in a manner plainly adverse to the title owners, and that gave notice to any other person claiming a right to the property by mowing and clearing trees and seeking building permits. So there you go. It was for business purposes there. So you said here, right to own and use, right to profit, use, right, sell, buy, trade, throw it away. Yeah, dispose of your property. Right to regulate, enforce, defend your property. Yeah. Again, this is we're trying to look at a way to get a title so that there's no dispute over who owns that property. And the intent of adverse possession is that you don't want a bunch of people just because they have the lion's share of the currency that they could go around and sit with legal title inactively and hoard land that could be more actively improved, developed, and used and maintained by people that the land is for. The land is not there for investments to be used by the people, that they can get the bounty the earth offers through their own exertions, not to hold it with a piece of paper and prevent people from using the bounty of the earth. So that's kind of the intent. What happened here? Oh, great. Geez. Once more does that, huh? All right, let's just get back to that. Give me 1 second here. We'll look at that while I'm switching around here. I got to fix something here real quick now because it's decided to put me onto the internet here. All right. Come on. Give me just a moment here. We're doing first possession. There it is. Okay. And there it goes there. Give me just a moment. Be back there in a second here. Oh, shoot. Just a moment. Okay, now we can get going. And we're back. All right. So Sorry about that craziness there. So let's see where we were. So we already hit this part here with the taxes. Some jurisdictions be visible. Okay, that's where we actually left off. Some jurisdictions also require that the possession or use of the property be visible, or that the possession be accompanied with an intent to hold against the true owner. When these elements coincide, title by adverse possession is acquired. If any one of the elements necessary to constitute adverse possession is absent, title by adverse possession cannot be gained. The existence of each element must be simultaneous and continuous for the required period. Simultaneous, at the same time, continuous without interruption, and for the required period, that entire duration. So yeah, there we go. It's pretty interesting stuff here. And what we got here, I see some stuff in the chat. In order to own your property, you must defend your property. You can't have a house in Galveston while you live in Seattle and then think someone isn't going to claim your Galveston home abandoned over a period of time, right? Because you shouldn't have to live in a wintry place all winter long. I mean, come on. You should be able to summer somewhere else if you wanted to. That being said, if it goes on for 20 years, I think you've abandoned the property is what it comes out to. So it really comes down to intent. And it's not to deprive people of having multiple residences, but it does prevent people from having multiple residences to use strictly as investments or deeds on paper to prevent other people from accessing it. Excuse me a second. Okay, let's continue. So we're reading this cumulative supplement. So paying the taxes this is a business doing this anyways, because they're doing building permits and they're clearing and mowing trees. They're probably doing stuff there. Oh shoot! Why does I keep doing that? I'll tell you why. This is pissing me off. It's a moment here. See if I can just refresh this stupid thing from where it is. There we go. Oh, okay. Well, now I know a new way to get it back. Cool. All right. We're getting with the technology here. So back to where we were. Landowner and his predecessors in interest exclusively possessed window wells that encroached on neighbors' property for statutory 10-year period, as needed for landowner to establish adverse possession of window wells. Predecessors in interest believed window wells were part of their property and used them exclusively to benefit their property while they owned it. And landowner knew window wells existed when he purchased the property and continued to use them exclusively to benefit his home, even after he discovered in a survey 3 years later they were on a neighbor's property. So he exclusively possessed. So how'd that end? Well, I'll make you read it, huh? All right, so there we go. Lots of case law to read for this. And then we get section 103 and 111 for color of title. All right. Enough of that. Let's move on to the next one. 10, necessity of title. Section 10. One claiming title by adverse possession always claims title in derogation of the right of the true owner, admitting that the legal title is in another. Thus, as a general rule, one who seeks to set up an adverse possession may not have a good title, or in fact any title, except a possession adverse and hostile to that of the true owner, under a pretense or claim of title. The adverse claimant rests the claim not on title, but on holding adversely to the true owner for the term prescribed by the statute of limitations. So yeah, it's color of title. Yeah, it's I'd say that the alligators looks like they're plenty the alligators are not too bad. I mean, it's they kind of keep in their place. You just don't want to surprise them. But yeah, definitely. Let's move along here. We got reminder. I love this part in American jurisprudence because they're really keeping you on track here. Adverse possession also may exist with color of title. And under some statutes, color of title is essential to the acquisition of title by adverse possession. So, wow, that's a pretty interesting concept here, and that's footnote 4, section 111. We could check that out real quick. We're on page 25, and we're going to check out section 111. That should be right about here. All right, pretty good. So section 111 is generally. So adverse possession may be established provided that other elements of adverse possession are met if the possession of property was under color of title, such as being an alternative to possession under a claim or right. Color of title, however, in the absence of a statutory requirement, is not a necessary element of adverse possession, and therefore ordinarily not necessary in an adverse possession claim that a claimant have color of title to land. All right, we got to look up this color of title thing because now I thought it was something much similar to what. Let's look it up here real quick. Give me a moment here. Color of title. Almost there. Let's see here. Color book. Man. Okay, so this should be close enough. All right. Color. Law. Color of office. Color of process. Color of title. 18th century, a written instrument or other evidence that appears to establish title, but does not in fact do so. Also termed apparent title. Wow. Color of title, so apparent title. Let's check that. Check out and see if there's anything different with apparent title. I'd like to see a good example of what one of these color of title or apparent titles are. Because it's kind of apparent. Here we go. 140. See if we get some clarity on what this is. Because if some states require it, I'm not sure if your state does. So what was the? Oh gosh. What was the word here? Gosh, I'm losing it here. Huh? Give me just a second here. Parent title. Why is it showing up here? Come on, get back. There we go. Parent title, color title. Okay, there it is. Yeah, I wanted to say fake or pseudo. Hey, I just like to go through this trouble so we'll never have to do it again. So it's just a self-reference here. Exactly. I'd like to just get a better example of what the darn thing is. Filing a notice in writing with the local justice court and then living there for a period of 3 to 7 years and the property is yours. In some states and jurisdictions, I believe so. It would depend. Again, there's statutes and things that are geared to address needs or, basically affordances for different environments, different locations and terrain and size of available land. Yeah, what looks like a title, but I mean, I'd like to. What would that be? Something written on a piece of paper with a crayon? All right. In certain jurisdictions, however, statutes may require that a claimant prove color of title to establish adverse possession, or in other words, an entry under color of title. Oh, okay. Or the subsequent acquisition of. Oh, okay. Before the possession. So, what you said here, I think, is it. Wait, that's not it. This one here. So that's your color of title, filing notice in writing first and living there. So they have, okay, thank you. You have rights, cops have duties. That's why you're in here. So filing this notice here, right. So even though it's not really a legitimate title, the fact that you have one registered in there means that you're there for that continuous time from the time you gave that color of title, so that once it matures, it will crystallize or become the full title. I get it. That's what it seems. So there it is. Seems like this stuff's a little bit simpler than at first sight, isn't it? Let's move along. Color of title, for purposes of adverse possession, where present, serves to extend actual possession to constructive possession. Color of title, therefore, may be used to show possession of an entire tract of property, even though the claimant adversely possesses only a small portion of the entire tract. Wow. Interesting. Observation: the requirements for acquiring title by adverse possession may be less stringent if the claimant enters under color of title than if the claimant does not. Adverse possession, however, cannot necessarily be proved by less evidence when the entry is under color of title than when it is not. Interesting stuff here. So there's your observation. Observations are usually just make everything more confusing, that there's more situations when you think you get it all figured out that you have to be cautious of the curveballs. Yeah, like when a guy gets stuck in a position with a large property and no longer has the means to upkeep and therefore must abandon the property for health or happy reasons. Right, and then there'll be another people will come in to maintain and improve and develop that land for posterity. Excellent. So we're moving along here, learning a lot as to what constitutes color of titles. Did we look at 118? We're going to look at that. Other elements, we saw that. And possession of property under claim of right. Let's look at this 118 really quick. What constitutes color of title generally? Well, we're already in a diversion, aren't we? Could you imagine being stuck and forced to remove the property and you have not the money, time, or strength? Right. So then, it's a lot of ways that could happen. So where we're going to 118, right? We're at 111. Here we go. Generally, color of title for purposes of adverse possession is that which gives the semblance or appearance of title, but which is not title in fact. It is an instrument, a record, or writing which, on its face, professes or appears to pass title, but fails to do so, such as, due to the lack of title in the person from whom it comes, or the defective mode of conveyance used. Color of title need not be an imperfect title of a sort that could, without aider, ripen into absolute title, but need only show some evidence, as you said you have rights, show some evidence of claimed ownership by the grantee. It is any semblance of a title by which the extent of a person's possession can be ascertained. Beautiful. Color of title as a basis for adverse possession depends entirely on the intent and meaning of the instrument purporting to convey title. A writing that does not on its face profess to pass title, but which expressly states that title will be conveyed at a future time and on certain conditions, is not sufficient to constitute color of title. Color of title can only arise out of a conveyance purporting to convey title to real property, but which, because of some defect, fails to do so. If an instrument actually passes the title to property, it is not color of title. So nice. That's pretty cool. Pretty cool stuff here. I like this. All right, so let's get back to where we were after that digression again. And we're on to personal property. All right. While a discussion of adverse possession ordinarily centers on real property, the same principle has been applied to the acquisition of title to personal property. Thus, if a person has the peaceable, undisturbed, open possession of personal property with an assertion of ownership for the term that would bar an action for its recovery by the true owner, the claimant has acquired title superior to that of the true owner, whose neglect to assert legal rights result in a loss of title. So we have a distinction here. Personal property is different from private property. Yes. So we're talking about personal property. I think they're just trying to differentiate it from public property, but not real property. So it's movable property that's not public. That seems to be a pretty clear distinction here. So cool. All right, so let's do this. For a person to acquire title to personal property by adverse possession, the possession must be under a claim of right and involve open, public, and notorious use. It must be actual, hostile, continuous, and exclusive for the applicable limitation term. Some statutes provide that a person who possesses a movable thing in good faith and by a just title as owner during a certain period without interruption will thereby acquire the ownership of it unless the thing had been stolen or lost. Could that be a car? In this case, let's see, as footnote 5, succession of Quaglino, 1957, Louisiana. Okay. And we're on to generally. So, under common law, the period for adverse possession of property was 20 years. And some states still use this as the period of time of possession required to establish title by adverse possession. Wow, so it was 20 years. They are tricky and try to word you out of your right to own, but to own is to hold, and no other way to hold is to defend. To defend is to not abandon. So yes, intent, maintenance, all these things are integral to establishing ownership. Indeed. So the length of time during which adverse possession must be maintained, however, varies in the different jurisdictions. Further, in some states, the period of possession required to establish title by adverse possession varies according to specified circumstances and requirements. Whatever the period required in the particular jurisdiction and under their particular circumstances, title by adverse possession cannot be acquired unless it is shown that the adverse possession continued for that period. So it has to be continued. Always remember the continuance is one of the elements that are required. A period of constructive possession under one statute of limitations cannot be tacked to a period of actual possession under another statute of limitations to make out the required time of possession to establish title by adverse possession. So, on your, see, that's under one statute, so depending on your jurisdiction. So cumulative supplement here, cases. So unless raised by another adverse possessor, the statute of limitations does not create a defense to an adverse possession claim. Wow, so you get two adverse possessors are the only ones that could have a defense to an adverse possession claim. Oh my gosh. This is why it's so important not to let the public service agents act like they own public, right? Not to let them tell your neighbors what you have to and not have to do on their property. Exactly. Remember, any of these public service agents, the public employees or public officers, they are simply custodians of the public trust. There are trustees, and we're the beneficiaries as the people. So they have to work for the benefit of us. Let's move along here. Okay, 30 years for real estate other than woodland or uncultivated tracts. 60 years for, wow, where is that? New Jersey. Oh, Louisiana, First Union Bank, New Jersey, 2001. 10 years for payment of taxes in color of title, and that's in Alabama. So yeah, 15 years in Kansas, it says here. Kentucky, 15 years. 10 years in Indiana, 10 years in Alaska. Beautiful stuff here, huh? Deadwood Summit, 2000. Looks like 10 years there. What is it for this one? Doesn't say. Okay, so there you go. Now, personal property, as you asked. Yes, for the sole benefit. Thank you. The beneficiary. Thank you there for that correction. Ordinarily, the period of adverse holding required for obtaining title to personal property by adverse possession is the same as the statutory period that bars an action for the recovery of personal property by the real owner. So your statute of limitations is the adverse holding period. Some statutes, however, specifically prescribe a certain time of adverse holding to acquire personal property by adverse possession. There you go. Anything interesting here? 1910, and there's that Quaglino again, Louisiana. And when position begins to run. All right, you're arguing too soon here. You have rights because we're about to get to that now. Wait till I'll argue after we get to this. So when position begins to run. Getting ahead of the lesson here. How'd that happen? The required period of possession to prove ownership of property by adverse possession begins when the rightful owner has been deprived of possession or displaced by someone exercising the powers and privileges of ownership. There you go. You're correct on that one. The remedies of trespass or ejectment must be available to the owner of the property before adverse possession begins to run. So, if there is an adverse possession of land under a mistaken entry, the statutory period for acquiring title by adverse possession runs from the date of entry and not from the discovery of the mistake. Again, you're correct. Yeah, I get it. You have rights. You should be running this one, I think, here. I should actually have you on the panel here to give the input instead of me. I'm reading this stuff here kind of as a request from last night's that we did on the deed. So this one kind of dovetails nicely into that. And again, this is something where I appreciate your input on this because you've really helped me understand this in better clarity. And there's nothing like doing something to understand it the best. And that's something that I appreciate your input. The statutes of limitations for recovery of real property begins to run when the cause of action accrues. And the cause of action accrues when the owner is deprived of possession. The fact that the owner is deprived of possession under a mistaken entry does not alter this rule. So there it is. The period applicable to an adverse possession claim should not start running until the title holder has a visible, objective reason to know that someone is trespassing. The period cannot run on the sly. So again, notorious, visible, right? As to trespass, we can see under the trespass, American jurisprudence. As to ejectment, Wow. Ejectments under American jurisprudence. Ejectment. Interesting one there, too. All right. That's some pretty great stuff we're getting through here tonight. Where are we at now? Generally. Okay, so let's look at this. Actual possession is an indispensable element in adverse possession. The actual possession of land necessary to constitute adverse possession requires a corporal occupation. And there must be an actual possession of at least some portions of the property to create a title by adverse possession. A mere intention on part of the claimant to claim land adversely, unaccompanied by a physical entry or of taking of possession of the land, will never ripen into title. Likewise, a claim of ownership in the absence of acts done upon the land indicating actual possession gives no title by adverse possession to the claimant. So we have to have acts done upon the land indicating actual possession. One claiming property adversely, therefore, must in actual possession of the property for the claim to be effective against the owner or before the title will vest by adverse possession. So you have to be in actual possession. Observation. One purpose of the actual possession requirement is to give the true owner notice of the extent of the trespass, because adverse possession generally does not extend beyond the land that the claimant actually occupies. And that's footnote 8. And in order to establish adverse possession, a claimant must show they had actual possession of the subject property. That's the Ruby River Canyon Ranch Limited versus Flynn, Wyoming, 2015. Why does that sound familiar? Okay, so we were looking at one of these footnotes here, right? 8. 1999, Maine. Interesting stuff there. Generally, some more here. Possession, actual possession for purposes of adverse possession has been defined as use and occupation of the property, or dominion over the property, defense, as you're saying, or as in possession, in fact, effected by actual entry on and actual occupancy of the premises. Similarly, it has been defined as a possession evidenced by such use and occupation of the claimed property as to establish a clear dominion over it. Actual possession, as has been defined as effective control over a definite area of land. Actual possession, you get that? Effective control over a definite area of land, evidenced by things visible to the eye or perceptible to the senses. Wow, that's some pretty good stuff there. Yeah, possession or holding is defense of the property. Exactly. Let's see here. You could rake the grass under the sagebrush where others can't see, but they still can. Right. As long as you can show that you did that improvement, right? There's evidence it was done. It can be seen or perceived to the senses, right? That's the evidence. It doesn't mean it has to be, that people have to notice at first glance, but once you draw their attention, they should be able to perceive it with their senses, the improvements you did, or the evidence that you've been there. Yeah, this is some powerful stuff. Super powerful stuff. And this is one of the beauties of America, too, because you're not going to find these laws like this for the people in too many other places in the world that I can think of. So let's appreciate some of these benefits of American jurisprudence that is afforded to all the people in America. Let's continue here. There is no fixed rule by which the actual possession of real property by an adverse claimant may be determined in all cases, because the determination of what constitutes possession of property for purposes of adverse possession depends on the facts in each case, and to a large extent on the character or nature of the premises. There may be an actual possession of real property without residence, cultivation of the lands, enclosure of the lands, optimal use of the lands, erection of buildings on the land, or personal or physical or actual occupation of the property. Isn't that interesting? A claimant's actual possession, however, requires something more than the mere occasional use of property. Thus, an occasional or periodic entry on the property does not constitute actual possession. Wow. Hey, we got Deborah Rogers. Welcome. All right, so some good stuff here. We're on to control and dominion. Actual possession, as required for adverse possession, requires a present ability to control the property possessed and an intent to exclude others from such control, or a general holding and occupancy. As you said there before, you have rights, right? Where is it there? Exactly. Seems like you've been reading ahead. Okay. With dominion over the property to the exclusion of others. The evidence of a claimant's actual possession thus must be sufficient to alert a reasonably diligent owner to the adverse possessor's exercise of dominion and control. To establish adverse possession, however, the claimant need not stand guard at all times on the border of the property to oppose the entry of trespassers or hostile claimants. It is enough if the person takes and maintains such possession and exercises such open dominion as ordinarily marks the conduct of owners in general in holding, managing, and caring for property of a similar nature and condition. So, pretty nice stuff here. I think that's pretty cool there. Yeah, we have something. Your family's facet was over, 150,000 acres. They toward the core property rights. So yeah, nice, yeah. Well, I think property rights should be important to every American. Because you don't have to go to the king for this stuff. I mean, when you look at it this way, yeah, some people might not like the legal system and the laws and such, but when you really think about it, it's a hell of a lot better than any other system of land ownership we've had since civilization, really. Life, liberty, and property. That's what we're guaranteed here to be protected. And this is right here. Property is what we're talking about. Our happiness. This is what this whole episode is about. Is about property. And there's many ways to acquire property, but where does it start before you can convey it to others? And there's a lot of empty land in this country. I mean, you could take a drive through this country in a lot of places and see there's a lot of land available. All right, so let's get here. The effect, nature, and character and location of property. So the determination of what acts amount to actual possession of property for purposes of adverse possession depend upon and varies with the nature, character, and location of the property. In other words, the type of possessory acts necessary to constitute actual possession for purposes of adverse possession in one case may not be essential in another due to the character and location of the property. See that? So we got, what are these elements? We have the nature of the property, the character of the property, and the location. What is actual possession for purposes of adverse possession may be one thing in a populous area, another thing in a sparsely settled area, and still a different thing in a city or village. Possession of an outlying or uncultivated piece of land, therefore, may be provided by acts of ownership somewhat different from those required with regard to land under enclosure and actual cultivation. Similarly, the acts of dominion necessary for adverse possession of a vacant lot need not be the same as with respect to a lot that is improved, and those acts that constitute possession of a residential lot may not constitute possession of a commercial lot. Furthermore, the act sufficient to demonstrate possession of wild, undeveloped land may fall short of the activity needed to establish possession of developed property for purposes of adverse possession, while the acts of possession required to establish adverse possession of woodland may be greater than is the case of swamp or marshland. Ooh. Okay. Interesting. So out here in Florida, we have the Everglades. And out in the Everglades, there's some mostly swamp, but there's some little areas that are higher than others. So they're kind of like islands almost out in the swamp. And some people build like little cabins out there. And you can pretty much only access it by airboat. So they have their airboats and they go out there and they have their cabins there. And they've had them for a very long time. And I believe some of them have developed an adverse possession of that land that they're on. Very interesting. That the fact that the swamp is so easy to achieve, the activity there of improvement because there's so little to improve. I mean, pretty much by putting your cabin there, you've improved it about as much as you can. So interesting stuff. This is this is a thing I was thinking about too. If they can make me not have my old car out back, they think they can make me take my entire house when I do. I defend. Yeah, it's there's no peace with it. Yeah, and this is the whole point of what we're learning here. Without a proper defense, and we're learning our defenses here. That's what's so great about this stuff here. And yeah, that's the alligator pits are great. Actually, I know one guy who has snapping turtles. The snapping turtle pits or ponds around his property. So yeah, you can go in and walk on his property. They're not the nice pond turtles that you see around the park. They could be worse than alligators because there's a lot of them. So yeah, alligator pits are a good idea. I mean, they're practical. You don't head out in the swamp without proper defense anyways, because of just the fact of those, the gators are prehistoric. Most of them will leave you alone, but the ones that want something aren't going to stop easily. Yeah, those snapping turtles can be mean. I mean, I love turtles, but snapping turtles are like a different breed altogether. Actual possession must be as definite as the character of the land will permit. Both the quality and quantity of possessory acts are necessary to establish a claim of adverse possession may vary with the characteristics of the land. Beautiful, beautiful stuff here. A person establishes actual possession of a woodland as an element of an adverse possession claim by residence or cultivation of a part of a tract of land to which the woodland belongs. Gosh, this is great stuff. And that's 2013. Okay, trolls. All right, so we're on to effect of potential uses of property. The determination of what acts amount to actual possession of property for purposes of adverse possession depends on the uses to which the property can be applied, or for which it is adapted. A claimant to establish actual possession must use the property for some purpose to which it is adapted, and it is sufficient that the possession be shown by the continued use of the property for the purpose for which it is susceptible. Wow. The standard to be applied to any particular tract of land is whether the possession comports with the ordinary management of similar lands by their owners, and if it does, satisfactory evidence of actual possession for adverse possession is furnished. This need to be similar to how other people manage it. An adverse possession, claimant's use of property thus need only be the ordinary use an owner would make of it to be an actual use, or possession for purposes of adverse possession. Great stuff. Rate the forest people. That's a good one there. Donnie Chimp, U.S. Ape. The adverse possessor, to actually possess land claimed by adverse possession, must act as the ordinary landowner would in utilizing the land for the ordinary use of which it is capable. That's Beaver Creek Ranch, Partnership, Colorado, 2009. Wow, good stuff here. And we're on to number 20 generally. All right, so this is a good place to stop, is number 20, because we've done a nice long stream tonight. We're just hitting that 2-hour mark, which is a good stopping point. A lot of people's eyes start to glaze over about now, so I'd like to keep it while we're still ahead of the game here. And I'm going to make a note here. It's page 45. That's section 20, generally. And we're doing adverse possession. This is some good stuff here. I think everyone should have gained a little bit of something new tonight, except for You Have Rights, Cops Have Duties, who's been doing this for decades. So he's probably knows more about this than all of us, and it's just, I guess, here to help us along, understanding that there's a lot to glean from this, and probably a lot of benefit for us to really exercise, I would say. And what we would say here is exactly when I am protesting the bad kind of work, I am belligerent and adverse. Hostile, I didn't threaten or shade. Yeah, with your case is a whole another thing I'd like to go over at some point, because there's some issues. I'm still a little bit confused on what the official rules were. All those players that were in that video there, You Have Rights, when the shoving thing was going on. And I don't care what they say, but as far as I can tell is that they came not there to do anything but to cause you harm. And what ensued from there is just a matter of defense, the way I see it. At least in Florida, it would be construed that way, I believe. Okay, yeah, well, we're all kind of glazing, but if you let it go too far, Archangel, then it's, it's not going to be good for anyone. Hey, Omnicolor Armor, thank you for coming. I really appreciate everyone showing up here. Again, this is really about learning about the beauty of the American jurisprudence that we have available to us. This is our court, this is our power, these are our rights, and these are our laws. And, there's no reason why there should be any kind of violence. Again, this is why You Have Rights, Cops Have Duties. It's your belligerent and adverse when claiming protest, is because, yes, our rights, our laws should prevent the violence and prevent these kinds of things. And when they start to violate the laws, it's only inviting the violence and the things that are not going to bring us a peaceful resolution. So, it's really a shame when we see those kind of abuses. But that being said, it's nice to see that we have the ability to use some of these laws that are common law in origin, and allow us to take advantage of this bounty of the earth we have available to us, that everyone should be able to share in, as long as that they can maintain, improve, develop, and utilize the land in its intended purposes, or the purposes it's susceptible for, and that's common to the normal uses of the time, place, area, and type of land. So time, title, nature, all of these things, and intent, as we see as a common theme throughout American jurisprudence, is that the law is supposed to adapt for the intention of meeting the needs of life, and not the other way around, where we have the legal system trying to make life adapt to its needs of acquiring a lot of property and money from the people. And in my eyes, it seems like it is a deprivation of our happiness whenever we're depriving people of property. Because life, liberty, and property are the essence of what it is to be American here. And it's been a long battle that our predecessors have fought and struggled to achieve what we have compared to our predecessors and civilization had to deal with. So it behooves us to take advantage of these powers, these laws, these benefits, and these protections that we have afforded to us, that have been given to us to use, and to make sure enshrine for posterity to have the advantage and benefit of using as well, and reciprocate the same generosity that our forefathers gave to us. On that note, I would like to say yes, basic needs met is what we want for everyone. And the world should be able to provide that easily. That being said, I want to thank everyone again for attending this journey of American jurisprudence. I really appreciate the support, the feedback, and the input on this. And again, this is something where it's a process that I'm learning too, and to be able to take everyone on this journey just makes it all the more meaningful for me. And I hope for you and the audience too that we do this together, that it is a fun thing as well as a learning and educational, enlightening, and mind-expanding experience. So on that, I would like to thank you all for coming, and I will see you all on the next one. Peace out.